Hello everyone. Hello everyone. Can we all hear me?
Yes, I can hear you.
All right. Good evening, everyone, and welcome to class. I'm having issues with my second device, so my camera may be turned off for a bit. But I will do well to work on that shortly. So welcome to class. We are officially in week 4 of the JIIPCC Mentorship and Internship program. Week 3, sorry, pardon me. Right, and we'll be starting the session right about now. All right, so not to waste our time, right? In today's class, we'll be discussing patients' rights. We'll be discussing patients' rights, evidence gathering, and legal remedies. So just to introduce our mentor once again, we'll be having Mr. Ebenezer. He would be the mentor for today's class. So I want us to kindly just sit back in, right, and try as much as possible to enjoy class, right? So as it's within our culture, right, in this particular class, we will be taking presentations from mentees first, right? So please, if we have the group presenters in class, both for group 1 and group 2, we'll be starting off with your presentation, and then we will move over to, we'll be starting off with your presentation, and then we'll move over to group 2's presentation before having presentation from the mentor. So please, if the presenter is in class, you can go ahead, share your slides, and start your presentation.
Yes, I'm in class, sir. Um,
All right, Zion, please go ahead and share your slides if you can.
Please, I have a question.
Please go ahead with your question.
Okay, so what group is starting the presentation, or are we to start presenting, or is anyone?
Okay, group 1. Sorry if I did not point
Yeah.
that out to this
Thank you.
presentation.
All right, group 1.
All right, are you the presenter for group 1?
I'm the presenter for group 2.
Okay, group 2.
Yes.
Okay, please can we presenter for group 1?
I'm the presenter for group 1, sir. I'll
Okay.
be sharing my slides. Sorry, sir.
All right.
Just give me one. Yes.
All right. Pass me this. Hello, Joy. Are you with us?
Yes, I am. Sorry, I have issues sharing the slides with everyone.
Okay. So let me see if I can quickly try and do that. Give me a minute.
All right.
Okay, I can see you already sharing your.
Okay, yes, sir.
Like, your screen, I
Good
mean.
evening. Yes, sir. Good evening, everyone. My name is Joya Buade from Kwon, and our topic is patients' rights and legal protection. So every patient have their rights, and if they understand these their rights, they'll be able to understand how they'll be treated, and they'll be able it will be able to prevent some issues that might occur where they don't if they don't know their rights. So they'll be able to communicate clearly, and they'll not have so much issues, little to no issues with medical practitioners or healthcare providers. So we have some rights such as confidentiality, right to privacy, right to quality care. So the first thing I'm talking on is informed consent. And Rule 19 of the Code of Medical Ethics in Nigeria provides that the consent of the patient must be attained by a medical practitioner after he has explained the procedure. So basically, informed consent is explaining basically when medical practitioners or healthcare providers explain the procedure, the benefits, and the risks of certain um of medical procedures. When they explain the risks of certain of medical procedures, sorry, informed consent occurs when the healthcare providers explains the risk, the benefits, and the medical procedures that will be under that will occur on or that they will undertake on the patient. So um so they have the right to informed consent, to
Hey,
be informed of.
can everyone hear her? The line is
Uh,
breaking here.
okay, we can hear us. We can hear us on this side.
Sorry, can you all hear me?
Please, yeah, we can hear you. Please go ahead with your presentation. I think it's for Mr. Ebenezer's end.
Oh, okay, thank you, sir. The next thing I'll be explaining is confidentiality and privacy. By Section 26 of the National Health Act established the duty of confidentiality. So basically, to explain this, the law provides that healthcare providers or the hospital is not meant to leak or show there's a leak any patient's medical records or anything apart from when generally the medical practitioners or the hospital is not expected to leak or show any patient's medical records or the patient's treatment records, medical records or whatever the has gone we undergone between the patient and the client. Sorry, I say client and the doctor, the medical practitioner, not meant to leak it. So unless there are some exceptions, and one of the exceptions is this right is also absolute and may be lawful and to be limited in following circumstances. For instance, when the patient consents in writing, where it is required by the law, in the case of a minor, yes, and an incapacitated person, and non-disclosure poses. Also, we have another right to quality care. Every patient has a right to receive care that is safe, effective, timely, and in line with the prevailing standards. And this care must be evidence-based and derived from accurate diagnosis and directed toward improving health outcomes while minimizing them. So basically, every patient has the right to receive quality care. And there's a case where in Odafe and others against the AG of the Federation and others, 2004, the court held that the failure of the state to provide medical treatment to prisoners with serious diseases violated the failure of them to provide this medical treatment has violated their right to enjoy the best attainable state or of physical and mental health. Basically, they have violated their right to quality care. So there are so many frameworks and laws that have been in place. Please, can anybody hear me?
Yes, we can.
All right. We have
Yes,
international framework. All right, thank you so much. We have international frameworks and we have local frameworks. International frameworks, we all know WHO, that's World Health Organization. We have International Covenant on Economic, Social, and Cultural Rights. We have the United Nations Convention on the Rights of Patients with Disabilities, and we have United Nations SDGs, UN SDGs, that's Sustainable Development Goals. We also have local frameworks like the Constitution of the Federal Republic of Nigeria, that's Chapter 4, which provides for fundamental human rights, Section 33, 34, and others. We have the Code of Medical Ethics in Nigeria, and we have the Discrimination Against Persons with Disability Act. We have HIV and Anti-Discrimination Act. We have Federal Competition and Consumer Protection Commission Patients Bill of Rights, and so on. We also have ethical issues in protecting patients. The first thing is autonomy. Yes, sometimes doctors or healthcare providers do not understand that every patient have their right to make decisions on their own. Therefore, they bring about this, they take paternalistic decisions, which will actually infringe on their rights or violate their right to autonomy. We have another one, dignity. And there was a case. There was actually a case. I read a case, and this person, they violated the patient's right to dignity, which is not so. And dignity is treating the patient with respect, compassion, and recognizing their inherent worth, whether or not they are minors or incapacitated persons. They still have their right to dignity as provided for in Section 34. Section 34 of the Federal Republic of Nigeria, of the 1999 Constitution of the Federal Republic of Nigeria. Then we have cultural insensitivity. Cultural insensitivity involves respecting and acknowledging a person's cultural beliefs, values, and practices in care delivery. In our first class, Barrister Ebenezer cited a case where a Jehovah Witness, yes, they wanted to transfuse blood, but due to the fact that the person was a Jehovah Witness, this fact that the person was a this fact that I'm so sorry for the underground noise. Due to the fact that the person was a Jehovah Witness, the person was unable to. The doctors still, or the healthcare providers still, they still continued with transfusing blood, even though they did not. Even though the person's parents or the mother, yes, did not assent to it. So basically, the right of a patient should be cultural. They should also understand cultural sensitivity of a patient and common violation of patients' rights. That's discrimination. We can talk about mental health issues where the patient has mental health issues. I talk about medical negligence, lack of information, and so on. Finally, we'll be talking on. Before I conclude, I'll talk on advocacy and patient empowerment. So, patient advocacy refers to efforts by individuals, groups, organizations to ensure patients' voices are heard, rights respected, and access to appropriate care is available. So, basically, these are persons who advocate for patients' rights. They are solicitors for patients' rights. And the key components to make advocacy and patient empowerment effective. The first thing is campaigns, awareness campaigns. Second thing, patients associations or organizations. We have community engagement, education and health literacy, policy advocacy, use of technology. So there are different ways patients advocacy can come to play. And we have challenges, which is lack of awareness, the person is ignorant of the rights, is our right. So these campaigns or this group can actually educate these patients of their rights. We have limited resources, representation issues, where the person does not have anyone to represent he or she, legal practitioner, either a legal practitioner or someone who is versed in the law. There's sustainability, mistrust, or cultural barriers. Yes, that's when the person is meant to be saved, but due to their cultural barriers, their religious reasons or religious beliefs, they end up probably killing the person, not killing as literally, but the person ends up dying because the person could not be saved because of their cultural beliefs, and we have measurements or evaluation. Thank you so much.
All right, thank you very much, Joy, for presenting on behalf of your group. We'll be moving over to group 2 for their presentation. So group presenter for group 2, please, you can go ahead and start your presentation.
Thank you very much. For this presentation, Zion will be sharing the slides because I was unable to do so. Thank you very much. Zion, I'm waiting on you.
Can I see my screen?
It's blank.
Okay, I'm coming. Can we see anything now?
No.
Or it's still blank?
Yes.
It's blank.
You can't see anything yet too.
No.
No,
Okay.
just give me so you can stop sharing your screen. Give me like
Okay.
2 seconds, 2 minutes. I would
It's not.
share. I'll share it on mine. Sorry, just give me a moment. I'm coming. I would be doing that shortly. Trying to open the slides. All right, please, you can go ahead. Just
All
let
right.
me know when you want to change.
Yeah. Okay. Thank you so much. Good evening, everyone. I hope I'm audible enough. Good evening, everyone. My name is Vivian Ian, and I'm the presenter for Group 2 for this week. Now, our topic for this week is evidence gathering and legal remedies. You can change the slide, please. We're going straight to introduction. The next slide, please. Thank you so much. Okay, so evidence is the backbone of any action. It is very important when you are bringing a claim or a case before anyone. It is the evidence that would be used to adjudge to see whether or not a thing happened or it did not happen. Because typically, if I should walk into a hospital or I should go to court after receiving treatment from a healthcare facility, and I'm claiming that, oh, these people amputated my leg or something of that sort, and they come and they're like, oh no, we didn't do that. It's basically my word against theirs. So what would help? What would show that this is the evidence? What would help is the evidence, is the hard, tangible evidence that, oh, indeed, you came to this hospital, you received treatment, and this was the procedure that was taken out. So evidence is very, very important in law. Now, there are types of medical evidence. You have hospital records, you have expert witnesses, you have operative notes, case notes. These are like the notes that the doctors take when they're attending to patients. They usually have case notes that they fill for every patient. There's a case note to be assigned to each patient. So you know what this person is coming in for, what drug has been administered to this particular person, and what the next step is. They usually do this in order to help the next doctor that would attend to the person, but it also, in the long run, forms part of the evidence, part of the patient's records that may be used eventually should the need arise. Thank you so much. So the next slide, please. Now, the standard of medical evidence. So medical cases or cases of medical negligence are not any different from your regular civil or criminal cases, but they are much more technical. So what governs evidence that is to be presented for such cases is still the Evidence Act, sections 14 and 15 expounds so much about the relevance and admissibility. And what governs admissibility of evidence is relevance. So for a piece of evidence to be admitted in law, it has to be relevant to the case. I cannot bring up a case and then I'm going to bring evidence that does not relate to the situation at hand. So for a piece of evidence to be admissible in law, it has to be relevant. Sections 14 and 15 of the Evidence Act 2011 as amended would expound so much on this. So admissibility, like I said, it has to be admissible. And what governs admissibility? Relevance. So that's just the major thing. For your evidence to be admissible, it has to be relevance. It also has to be reliable. So patients' records, case notes, operative notes, all of that, they have to be reliable. Even samples, they have to be brought from safe custody. They cannot just have been thrown about and then you bring it from anywhere. It has to have emanated from the hospital that you are laying claims against, that, oh, something has occurred, something has gone wrong. So your evidence has to be reliable. You can't just pick anything from anywhere and bring it as evidence. It has to have emanated from proper custody. That's for reliability. Documentation. Now, if you walk into the hospital seeking treatment or whatsoever, for every time the doctor sees you, every time any drug is administered to you, every time anything is happening to you in their facility, from the moment you walk in till the moment you cease being a patient of said facility, everything is supposed to be taken down. It is supposed to be recorded because, like I said, evidence is very, very paramount to all cases, not just medical cases, but all cases now. Everything is to be documented so that they would know, oh, this is where we started treating you and stopped. This is what happened next. This is what happened next. It helps in the long run should a case arise and it would require solution. That evidence is what would be referred to at the end of the day. So it has to be documented, and it has to be documented in a timely form. You cannot document something that is going to happen before you've seen the patient. You're not a mind reader, so you have to document it as it is going on, as it occurs, as it comes. You document the things as they are happening. Now, it has to be clear, legible. If not, it would be inadmissible. It has to be confidential. It has to follow the proper rules and the proper laws. Should it be found that it is flouting any one of the data protection laws or any of that sort, or it was gotten illegally, that evidence may be quashed and reliance may not be placed on it. And that could be the fine line between a conviction and a dismissal, really. So evidence is important, and it is important for them to follow the right procedures and to follow the rules governing evidence and presentation of evidence in order for it to be admissible. Thank you so much. Please, the next slides. Challenges of gathering medical evidence. Thank you. Thank you. So one of the challenges of gathering medical evidence are tampering. When people try to forge documents or alter documents just to save themselves or to cover up things that have occurred that should not have occurred, these are one of the challenges that people face in gathering medical evidence. Also, some hospitals may refuse to release some documents to you, like your patient history and all of that. You may be refused. So these are the challenges that are faced. And some other times there are issues like human error, time pressure, lack of training, So if people do not know how to take the proper notes and in what form to take down these notes and take down these records, when you want to rely on such records for evidence sake, they may not be admissible because they are lacking in one way or the other. And you also have paper-based systems. You know how things can get lost when you record them on paper. They may be burnt, they are prone to fire hazard, prone to theft even. And same thing with technical issues. So you may have a malware that just crashes the whole system. If you were using an e-system of recording, malware can crash the whole system and then everything just goes down. So it's back to square one and you don't really have evidence. You don't really have anything to start from. You don't have where to start from. So these are the issues. Like I said, bureaucracy to high fees, privacy laws here, and lack of awareness. Some people don't know that they are entitled to some records should they need them. So it proves difficult when should the need arise. Thank you. Please, the next slide. Thank you. So there are some remedies. There are some legal remedies. So you have compensation, monetary compensation. This is payments to victims or payments to victims who have suffered a particular loss or the other as a result of medical negligence when the evidence is brought and it is relied upon and it in fact proves that, oh, this happened, this that the person was complaining of happened. Now the other party would be entitled to pay to compensate the complaining party, the claimant rather, would be entitled to compensate not the claimant, but the judgments, the person whom judgment was awarded in favor of. So you'll be entitled to compensate the person. Injunctions could also be ordered. Now, injunctions could be to order a person to do a thing or to restrain a person from doing a thing. So injunction can be ordered to request for a particular record that may be paramount to a particular case. So that's injunctions. And then disciplinary actions could also be meted out. So we would, the next two slides, I want to go to the cases. So in the case of Ojo and Garuru, this particular lady claimed that the hospital performed surgery on her and then they left a needle in her body cavity. Now, for medical negligence cases, in order to prove the burden of proof is usually on the person claiming such. So it was on the claimant, and now she failed to bring expert evidence and all of that. There were no records, there was no evidence whatsoever. It was just her word against the hospitals that, oh, they left a broken piece of needle in her body cavity. So when the matter had gone from the trial court to the Supreme Court, and at the Supreme Court, it was ruled that since she failed to provide expert evidence, that she had no case. So she lost the case there. She had no case whatsoever because she failed to provide expert evidence. She failed to provide records. So there was nothing for her. In another case of, on the flip side, in the case of Montgomery versus Lanarkshire Health Authority, so this lady, she was pregnant and her doctors failed to inform her. Informed consent, as we've learned, is one of the rights of a patient. You have the right to be informed about your procedures and other alternatives available to you. So she was to give birth, but the doctor failed to inform her about the side effects or the dangers of, she was a diabetic, so she was to give birth. The doctors did not inform her of the effects or anything that could happen and did not present her with the option for a cesarean section. So by the time she had given the birth vaginally, she suffered shoulder dystocia. And how were they able to prove this? Because there was no form that was filled that, oh, she had been informed of the dangers of giving birth that way, or that she had been informed of the alternative. So there was no form whatsoever. There was none of that. So there was no record proving that the hospital had done their duty in that sense. So that was how she won the case, because the hospital failed to inform her. The next, okay, conclusion, please. So in essence, evidence is very important in all cases, especially in medical cases. They form the backbone because the judges are not there, your lawyers are not there when you are receiving this healthcare. So what they would rely on is the evidence adduced, is the evidence produced. So if there is no evidence, it all goes to naught. There would not be a case and they would not be able to prove a thing without evidence being presented. Also, alternative dispute resolution mechanisms are important as well. It is important when trying to resolve these disputes that arise in in medical cases. They're usually important. They're more cost effective than litigation. They are more private. They also help to maintain a friendly environment as opposed to the animosity that comes with litigation. So ADR mechanisms are also useful and helpful when trying to settle medical cases. Thank you very much for your audience. That would be all from group 2. Thank you.
All right, thank you very much, group presenter Vivian, and thank you to Joy for both the presentations that were made in class. Right, they were very detailed and to the point. Right, so please, we'll be taking, I don't know, Mr. Ebenezer, is he around? I can see his network has been fluctuating. He has been coming in and going out. Right, I hope he's able to join us back shortly. His network just disconnected again. Right, so we sincerely apologize for all the issues that has been here, because of the network itself. Right, but he will be shortly joining us. Okay, Mr. Ebenezer, I can see you are back. Welcome back, sir. So I don't know if you were able to catch portions of the presentations, but based off of the presentations that were sent to you and what you have on today's class, we would like to just hear from you in a few minutes. Okay, this network has got him out again. Let me. Hello, Mr. Ebenezer. Are you with us, sir? Um, Hello, everyone. Can you all hear me? Please, can someone confirm that they can hear me?
Yes, sir.
Yes, sir, you're audible.
All right.
Yes, sir.
So because of the particular challenges that Mr. Ebenezer is having with his network, he has kindly requested that please we should reschedule this particular class for Tuesday, right, for Tuesday by 4 p.m. So I want to kindly plead with us that we'll be rescheduling this particular session for Tuesday. So I'll be sending a notice in the group so that we can have a proper session on Tuesday without all these, without the technical challenges around the network. We sincerely do apologize for every discomfort or inconvenience, if I would use properly, that the network has posed to this particular class. Right. We hope that on Tuesday it's going to be better, and we will make sure, okay, because Mr. Ebenezer said it's raining over at his place, right? So we hope that on Tuesday and on Sunday we will not have those particular issues. So what we will do in regards to Sunday class, because you're also supposed to get your tax for the week, a new tax for the week, we would send you a new tax for the week today, right? So you
Hello,
will be,
hello,
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 hello, sir.
hello, Dennis. Can you
Your voice is breaking, sir.
hear me? I think it's a bit stable, and the network was misbehaving. Not okay, staying unstable. Now that the rain has started, the network is a bit stable. We have taken group 1. So
Yes,
is it
sir.
possible we meet on Tuesday afternoon, Tuesday 4 p.m.? Is it convenient? Is there another class holding on that day?
No, they're using, sir. So we're
Okay.
already making the announcement that will be shooting the class on Tuesday.
Okay. Please. But I would like to say that I am impressed so far with the depth of research. Let's continue. The thing is stable now, and it's surprising me. Wherever it logs us out, we go. So maybe we can quickly speak to the presentation of group 1. I know that it is group 2 that we have left. If it
When you
logs
were
us out anywhere,
Sean,
then you said?
I said while you were away, sir, group two also made presentation. While you were away, sir, group two also made
Okay, has group
presentation,
2
sir.
completed their presentation? I was coming in and out. Has group 2 completed their presentation?
Yes,
Oh,
sir.
yes,
Okay, awesome.
yes,
So
sir, they have.
let's continue. If anywhere it logs us out, we know that's where we'll end it for today. But honestly, it's surprising. When the rain had not started, the network was misbehaving. Now that it is raining, Okay, so patients' rights. Firstly, let me commend the depth of, okay, before I go into that, how many of you participated in my lecture within the week? How many? How many? Just raise your hand or unmute and answer. How many of you participated in the webinar? Okay, Bolanle, good. Who else? Who else? Okay, Priscilla. Okay. Who else? Priscilla, you presented for group 1, right?
No, sir, I'm not the one that presented for
Hello?
group one.
Hello,
I'm not the
Priscilla.
one that presented, sir.
You were the presenter for
No,
group 1,
sir.
right? Unmute and speak,
No,
please.
sir, no. Can you hear me? I'm not the one that presented.
Okay, are you in group 1? Are you in group
I'm
1?
in group two. I'm in group two.
Okay. So who presented for group 1? Who did the work for group 1?
I did, sir.
The name, please.
Joy.
Joy. Okay. Did you attend the webinar too?
Yes, I did.
Okay, let me comment. Okay, because I saw that you did a lot of materials from the webinar, and that was relatively wise. Well, I commend your work. I commend the research. I sincerely commend it. And this that if you didn't bear me witness, this you people are serious in terms of research.
So it seems this network doesn't want to allow us have this class today, right? So I guess what we'll do is that we'll just have this class on Tuesday, so that we don't keep struggling, right? So please I will send him a notice, for us to have the class on Tuesday. Please, once again, our kind apologies, right? Please see you all on Tuesday. Like I said, I will send the new tax for the week. And also what we will just do is, I'm sure Tuesday class will most likely be for an hour or so. So please just try as much as possible to squeeze time, right, to be in class on Tuesday. Thank you very much for your understanding, and please see you all on Tuesday. Thank you very much.
Thank you, sir.
All right.